Hi everyone. So Title 9 is relatively short and I hope that this is a short video. Now, Section 75 talks about two or more corporations. The reason why I am highlighting corporations is because a partnership cannot be merged with a corporation. Either that or it's not covered by Section 75. Now, either a constituent corporation will be formed if it's a merger, and for consolidation, where a new corporation will be formed is called a consolidated corporation. Excuse me. What is required is that there should be a plan of merger or a plan of consolidation which sets forth the items here from A to D. So just please read that on your own time. Section 76 talks about stockholders or members' approval. Now, it says here that the notice from this word, it's on a separate page. Notice shall be given to all in accordance with Section 49. So if you remember Section 49, for regular meetings, that's 21 days notice. And for special meetings, it's 1 week's notice. And the approval must be made, if I may just go back a bit, the approval must be made by the stockholders or members at separate corporate meetings. So there cannot be a joint meeting for both, even if it's the same agenda anyway. When you talk about the votes, it must be 2/3 of outstanding capital stock, which includes non-voting shares. So I'll just put NVS. Because if you remember Section 6F, these are one of the things that non-voting shares cannot be deprived of the right to vote on. Why? Because even if they are not voting shares, a merger or consolidation will affect their investment because it's possible that it's a bad business decision and they might want to opt out of it as well. That's why there is the right of appraisal in cases of merger or consolidation for those who dissent. The same voting requirement is also required for amendments. Now, Section 77 talks about the articles of merger. If there's an articles of incorporation, when you start a corporation from scratch, when two corporations merge to one, or when one merger buys out the other, technically, since there's still a difference in corporate structure, then there will be another set of articles. And the items that must be stated there are from letters A until letter G. When is the merger effective? The merger is effective upon the approval of the SEC. Therefore, the SEC's approval is the operative act that makes the merger effective. And you will see that when you look at this section. When the merger or consolidation is concerns banks, banking institutions, etc., the types of corporations stated here, or special corporation and other special corporations governed by special laws, there needs to be a favorable recommendations. If you've noticed, although there are so many provisions under the corporation code, it's relatively there's a pattern in a sense that for certain articles there are times where if it affects the structure of the corporation, there would a favorable recommendation from the appropriate government agencies usually required. The commission, if the commission approves of the articles and the plan of merger, then it will issue a certificate approving the articles and plan, at which point it will be effective. That's why I said it's the operative act. The approval is the operative act. Why is it important to know when the effectivity is? Because that's when the non-surviving corporations dissolve. But even if there is a dissolution, there is no winding up of affairs because the assets and the liabilities of the acquired corporation will be automatically moved to the acquiring or to the consolidated corporation. What are the effects? So about the investigation, it's self-explanatory. Section 79, what are the effects of merger? It's just stated here. So these are relatively self-explanatory. mainly because practically the definition of a merger and a consolidation is here already. Just take note that what I just mentioned about the assets and the liabilities under letter D, the surviving or the consolidated corporation shall possess all rights, privileges, immunities, and franchises of each constituent corporations, and all real or personal property, all receivables due, including subscriptions to shares and other action and other choices in action, and over every other interest due to each constituent corporation shall be deemed transferred to without further act. That's why I said a while ago it's automatic. Corollarily, the surviving or consolidated corporation shall be responsible for all liabilities of the constituent corporations, etc., etc. So, very self-explanatory. Although we would hope that the video ends there, let me just make a few points. A merger is one where a corporation absorbs another corporation, whereas a consolidation is where a new corporation is created and the consolidating corporations are extinguished. Since a merger and consolidation involves fundamental changes in the corporation, as what I mentioned earlier, there must be an express provision of law authorizing the same. That's why there's an entire title, Title 9, dedicated to merger and consolidation. Even though I stressed that the approval of the SEC is the operative act as to when the consolidated corporation or the new corporation is formed, or when the merger takes effect, rather, the SEC opined that the revised corporation code does not prevent the parties from agreeing on the effective date of the merger. So I just want to say in passing, although I don't know if you really want to know this, there's a thing in other jurisdictions called a triangular merger, where the acquiring corporation will create a subsidiary, and that subsidiary will be the one to merge or consolidate with the acquired corporation. So this is sometimes called a phantom merger or a reverse phantom merger. Why is there usually a triangular merger in other jurisdictions? It's usually because the acquiring corporation wants to keep the business of the acquired company separate from the acquiring company. Or it may also facilitate the sale of the acquired company. I hope you don't get confused with acquired and acquiring. How about foreign corporations? Are they allowed to participate in a merger or consolidation? The answer is yes, because that is explicitly provided for in Section 149 of the Revised Corporation Code. So just read through that, but we will discuss that when we get to that provision. Now, be careful, because a merger and a transfer of property are different. Unless there is evident intention, a mere purchase or acquisition of another corporation's assets or property does not constitute merger or consolidation, even if it is advertised by the parties as a merger or consolidation, or even if there's an assumption of liability on the part of the purchasing corporation. This is especially true, meaning it's obvious that it's not a merger or consolidation where the selling corporation retains its franchise. What are combinations? You might be hearing those, I think, in your advanced accounting. A combination is the generic term because it means an alliance or transactions between two or more corporations that's not necessarily result in the loss of the existence of one or more of the corporations. Excuse me. When you talk about combinations, it's an umbrella type of business transaction. It includes stock acquisition, execution of a voting trust agreement, formation of a holding company, or even the transfer of the assets from one corporation to another. In a sense, mergers and consolidations are part of business combinations. A partnership can enter into a combination with a corporation, but a partnership cannot merge or consolidate with a corporation. That's why I needed to distinguish between the two terms. Excuse me. So again, although there is a dissolution of the absorbed corporations, there is no winding up of their affairs because the surviving corporation automatically acquires all their rights, privileges, as well as their liabilities. That's what I just mentioned under letters D and E of Section 79. So in a merger, the properties of the non-surviving corporation or the acquired corporation are not sold to the surviving corporation. These are absorbed by operation of law, as they are automatically transferred without any further act or deed, as you can see on your screen right now. It's highlighted. And because of this, the employees are not dismissed, and their service continues. So when it comes to computing for their retirement benefit later on, their service even before the merger or consolidation is counted as their service all throughout. So therefore, to dismiss employees based on the fact that there's a merger or consolidation is illegal. How about the Philippine Competition Act? I just want to mention that under the Philippine Competition Act, there is mandatory notice by the parties to inform the Philippine Competition Commission that they are to undergo a merger or consolidation. Why? Because the Philippine Competition Act must ensure that there is that agreements do not prevent, restrict, or lessen competition. The prohibition applies if the merger or consolidation is horizontal, meaning merger of competitors, or vertical mergers, those involving a client and a customer. And if the parties fail to notify the PCC within 30 days from signing the agreements, then the agreement is void, and the parties can actually be administratively liable. There are two tests used by the Philippine Competition Authority or Philippine Competition Commission. It's the size of entity test and the size of the transaction test. So I will not discuss that anymore. Once they notify the PCC now has 90 days to investigate or to review the agreements. If they fail to arrive at a judgment within 90 days, then they are deemed approved. How about religious corporations? Can they be merged one with another? The answer is yes, because they're both corporations. For practical reasons, however, the SEC opined that they must belong to the same religious denomination. So can you imagine if they weren't? Then that would be, war. What about while a merger and consolidation is part of combination, it's technically part of a reorganization. So a reorganization is also an umbrella term that includes statutory merger or consolidation, the acquisition by one corporation of the stock of another solely in exchange for its voting stock or the voting stock of its parent, the acquisition by one corporation of substantially all of the assets of another in exchange for the voting stock, a transfer by a corporation of all or part of its assets to another if immediately after the transfer, the transferor or one or more of its shareholders is in control of the corporation, recapitalization, a mere change in entity, form, or place of organization, and transfer by a corporation of all or part of its assets to another corporation in a bankruptcy or insolvency case or similar proceeding. So a reorganization has a stricter it has a narrower type of business transaction than a combination. If you look at the similarities between the types of reorganizations, then you would see that in effect it's like almost like a merger consolidation already. What about quasi reorganization? I know it's an accounting procedure and I'm sure you've heard of it before. Pardon my retainers. Quasi reorganization is when the company tries to amend either the articles or to reappraise its property to find if there is any reappraisal surplus, in which both cases are used to wipe out the corporation's deficit. Under the SEC rules, only companies that are financially in distress may be allowed to undergo quasi reorganization. Since we're talking about the different types of mergers and acquisitions, you've noticed since we've been reading law on partnership, there's always a de facto version. There's a de facto corporation, there's a de facto partnership, there's a de facto merger and consolidation. What does de facto mean again? It means it does not strictly comply with the requirements under the law. So it's like a merger or consolidation. And in a de facto merger or corporation, a de facto merger rather, has been defined by the Supreme Court as an instance where one corporation acquires all or substantially all of the properties of another in exchange for shares of stock. In that case, the target or the acquired corporation would end up with basically just the shares of stock of the acquiring and no other assets. So this is a type of a business entity transfer. In other jurisdictions, a de facto merger or consolidation entitles a dissenting stockholder to the right of appraisal. So while it is not clearly stated under the rules, if you will look at Section 80, it also applies to a de facto merger or consolidation. So that's Title 9. Bilis lang, no? And I will see you for Title 10.